So we just finished talking about bidding, and now after you've bid and you submit your proposal, you find out that you have won the project. Well, congratulations. What does that really mean? So if you won the project and you are now going to start negotiations, you still have to get through a sometimes long process of negotiating the key legal terms. And you can also at this point still be negotiating the price, even though you won on the price that you submitted in your proposal. Um, so a lot of things that can happen at this point. You can have an easy negotiation, or you can have a client. Some public agencies don't engage in a tremendous amount of negotiation, and so sometimes you have an easy negotiation purely because there isn't much negotiation. Or you can potentially have a very difficult negotiation. I have seen I have seen where there is an award for, at least in public and private projects, on a price, and then there's a request by clients to significantly cut down the price in terms of cost savings, and then you are stuck with having to decide whether or not you want to continue to pursue the project at this point under the new reduced fee, or whether you want to potentially walk away from a project, which is difficult after you've been awarded a project. Um, so you start to engage in the negotiation of the agreement. And what might happen is that you may not come to an agreement. And so the question is, what happens then? So there's a few things that can happen. Typically, courts will look and see that if you were negotiating an agreement, and for some reason it stopped, but it appeared as if you were pretty close and you had a meeting of minds, the court may find that that agreement that was, incomplete or half finished, may essentially be binding on the parties. So an example of this, which I have seen, in the real world, is that a party is awarded a project, they they start a negotiation, something happens, the client's either not responsive, the client is looking, and this is pretty common, the client is looking for additional funding, and they don't want to finalize an agreement until they can maybe, hammer out the details of their funding, because they think that potentially maybe the legal terms will need to change a little bit based upon that separate agreement that they're going to have. And so there is a protracted negotiation that lasts longer than it was supposed to. Um, and then for whatever reason, people forget and it never gets completed. But at the same time, the parties are continuing along on the project, as if everything is fine, where the contractor is providing work, where the architect and engineer is providing work, and the client is paying as if they had an agreement in place. In a situation like that, depending on how developed the draft agreement was, a court may be likely to say, well, that agreement, in terms of the terms that weren't clearly still open, is binding on the parties, because of the fact that it did appear as if they had a general agreement, at least in principle, and they both were performing what they needed to be doing underneath the agreement, the owner in terms of paying, and the contractor or the architect and engineer in terms of providing the services in exchange for that payment. What also can happen is that you start a negotiation, and you start to work, um, and then the negotiation falls apart. So similar fact circumstances where you start work, perhaps the owner starts paying, and then at some point there's a realization that the parties will never come to a legal agreement in terms of a pure contract. I have seen this happen. I had a project a bunch of years ago where we started, the firm I work for started work. We eventually got to a point where we had a very, very lengthy contractual negotiation. It became very clear that the client was not going to give in on certain terms, and we were not going to give in on certain terms. And there was a decision that had to be made as to whether or not we would, continue work or not continue work, and what was going to happen with the agreement that was, still half complete. And so what happened in that instance is in essence, both parties just dropped the agreement knowingly. We just put the agreement down, and there was a decision by both parties to just proceed with the project, but without any sort of a formal contractual document. In that instance, and I am thankful that it was never actually tested, but in that instance, it would be interesting to see what a court would say, given the fact that there had been some negotiation of the contract terms, and at some point it became very clear that we were not in agreement on the terms, yet we were in some ways both parties continuing to perform under some terms of the agreement and choosing to ignore some terms of the agreement, that the draft agreement. Like I said, I'm glad that we never had to find out if a court would have upheld the draft agreement, but that can happen where the negotiation ends at some point, but the parties decide that they just are better off continuing to go forward with the project, but with a lack of a clear contract. What also can happen is that you can start work, and I see this happen a lot, and I advise against it, but you can start work before you enter into an agreement, and then the project potentially either stops or there's some other reason as to why the parties don't eventually come to an agreement. Those are some of, in my opinion, the worst situations to be in. As I said before, I typically at least strongly advise my clients that you should very much try not to start work without a signed agreement or some other form of agreement, whether that is what I call an agreement light, which could be something like a letter of intent, which if you're not familiar with, is a couple of page documents significantly shorter than an agreement that pretty much just says, we agree to the following things at a very high level, and typically you will try to include, payment or fee, and kind of the really, really important terms in a letter of intent. I strongly suggest if you are going to start any work before you are executing an agreement, that you do have some sort of written document, at least in terms of the fee or when you could terminate, or if you're an architect and an engineer, the fee and what happens to the drawings, if for some reason the agreement never happens or the project stalls or the project stops, so that there isn't an ambiguity, or you're not forced at some point to be working and not getting paid, because there isn't an agreement at that point, and things for whatever reason decide that they are not going to continue.